There are some indications on the defendant's electronic devices. There are other young girls on there and indications of contact with other young girls.
Bond. James Bond.
There's a bond motion on that. I have read the bond motion. I will let the emergency bond motion of the people. I've read that bond motion. I also will let counsel know that because of what was contained in the motion, I went and I viewed the early this morning. I reviewed the video of the arraignment itself, so that I know what was at least said to the magistrate, what the magistrate was informed of, and then had received documentation, I think, which has been shared with defense counsel, or at least they were CC'd on the emails from the people. So
that is correct.
Was there anything else that the people needed to add to the bond motion or request for bond on the other case?
No, Your Honor, I am just going to state a few things for the record. People had requested in the criminal sexual conduct case a $100,000 cash assurance bond. I don't know exactly, I was not at that arraignment. I don't know what exactly was happening, Your Honor is aware. But in my bond form request, I did state that the defendant had sent a photograph of himself with weapons to the 14-year-old victim in that CSE case, which I believe the nature of the charge that he had sex with a 14-year-old child and sending a photo of himself with those weapons is enough to make him a danger to the community and a danger to that victim in that case. And then when the defendant was arrested on that warrant on the 2nd, he ran from police who identified themselves and then dropped a loaded handgun as he was running away. He is also the suspect in an AWIM case in which 2 weapons were located, and those weapons we believe are the same weapons that he was in that photo that he sent to the victim. So I have extreme concerns that defendant had weapons. That AWIM happened in mid-December. He had those weapons. He ditched those weapons. Between that time of 15 days, he acquired new weapons. I have safety concerns just based on the acquisition of numerous dangerous weapons, and that he has a pending CSC involving a child. So I am requesting a $100,000 cash bond on the CSC and a $75,000 cash bond on the new charges he was just arraigned on.
Ms. Gaines, before you go, Ms. Gaines, one thing I was not able to figure out, and maybe counsel can help me. Out of Macomb County, he's on a tether.
That is.
Was he on the tether prior to September of 2023, or did the tether happen after September of 23?
I will have to ask him. I don't think we began representing him until after that time.
Correct, but
He's stating that he was on the tether prior to September of 2023.
okay. So, and just so you know why I asked that, my concern about that is he's on a tether for a felony out of Macomb, and in relation then to the dates of these offenses, then commits these offenses while on tether. Which I think those that have been before me, and I think it's something certainly the court can take into account. That's a big factor for me if somebody is on bond on some other case and then something else is alleged to have happened. But I'll let you go, Ms. Halsinger.
Your Honor.
Yes.
First of all, I believe that reading the motion that the magistrate was aware of most, if not all, of the allegations that were listed in the motion and was able to consider those things when setting the bond, and that at no point was there an abuse of discretion in setting the bond at the level it is, that the bond that was set in terms of him continuing with the tether to not have any contact with the complainant, to not have any weapons. All those conditions address all of the concerns that were placed, all the concerns that were indicated by the prosecutor. In addition, Mr. Moore is a single parent. He has primary care of his 4-month-old daughter, who will be 5 months old on the 20th this month. He actually appeared in court with her on one of his very first court dates before, Your Honor. The mother is not positioned to have full-time care, and so he is the primary caregiver. He is working. He works at Meyer. He's been working there for approximately 2 months. It is his belief that he would be able to return to that job. That's how he works to support his daughter. He has no objection to the conditions of his bond being house arrest. And although he would prefer to be able to continue to work to take care of his daughter, if Your Honor were to require home confinement so that he could not leave, then he would abide by that. In terms of some of the allegations and of the that were made with regard to the bond, he very much denies having sent a photograph with weapons to the complainant in this matter. He states he does have a public Instagram, and that in the early part of December 8th, he was part of a music video that was filmed at the Wyndham Hotel off of right there on Jackson Road. And that the photos were taken there, and that they were not loaded weapons, that they were used as props as part of the video shoot. He indicates that I believe the order also says that he not return to WAVE, and he states that that will not be a problem. One of his mothers does work at WAVE, and he had been a student at WAVE, but he has no issues with no longer returning to WAVE. He resides with his brother. He and his daughter reside with his brother and his brother's girlfriend in the on Bynum Drive, not that far, close enough for him to get to work. And that's where he's been residing. He states that he has been working with Derek Jackson and with Marvin, I know his last name, I did not write it down, in doing community outreach, in working with them in community outreach. He's an active participant. He states in My Brother's Keeper. He also participates in the Formula 734 music resiliency program that Mr. Jamal Buford runs. He has not missed any of his court dates in Macomb County, and he has not missed any of his court dates here in Washtenaw. So he would appear for court. The conditions would ensure that he not be of a concern to the court, and in particular, if there is the requirement of the house arrest, there would not be any danger of harm or potential harm to the community if Your Honor is concerned about that. And so we'd ask that the court either keep the bond that Magistrate Fink set an identical bond in the new matter, or in the alternative, set a bond where he would be on GPS tether. I believe he's on GPS tether now. Is that correct? And that he be on house arrest, and that he have no contact with the complainant, not go to way of school, not possess any firearms.
I don't know. Thank you. All right. Is there anything else from the people?
Nothing additional, Your Honor.
Was there something else you wanted to say?
Mr. Moore did want you to know that, and I don't know if you would want to entertain him speaking for himself, but I asked him what he was going to say, and that, he has no problem with house arrest, with staying on the tether. I believe the tether is now Macomb tether, but if Your Honor wants a tether out of this county on him, he has no problem with that. And just so that he can make sure that he's available to take care.
But also, just so that we know, he was just released from parole in November 2022, right?
No, that's not my understanding from him. He is indicating to me that he served his complete prison sentence. That's what he says. He stated to me, and that he was actually, his release from the Michigan Department of Corrections was from a correctional facility in November of 2022, not.
Okay. The same idea, I guess, because he's released November 2022. Between November of 2022 and September of 2023, he picks up additional charges out of Macomb. He's placed on a tether, on bond and on a tether, my understanding. I don't know if he was actually pled or something happened in his sentence, but anyway, he's on a tether on release. These offenses then come up on, or are alleged to have occurred in September of 2023, right? Ultimately, he's arrested out of Washtenaw on these charges at some subsequent point and now here. Okay, so I get all of that. That 1 year.
May I just add that I believe that those Macomb County charges are also weapons offenses for which he is on bond for.
So the Macomb County, he had informed the magistrate that it was just the receipt and concealment of a motor vehicle. But you believe that there are weapons charges with that?
Yes, in his lien, I can see arrest 6/14/2023. In the judicial segment, it's showing that these were bound over to the 16th Circuit Court, so I don't know where they're at, but there is a felony for weapons receiving and concealing firearms.
Got it.
And then also motor vehicle receiving and concealing possession of a firearm by a felon and felony firearm 2 counts.
So it's my understanding from Mr. Moore that those matters are pending still. He indicated that he had a court-appointed attorney who passed away, and so they're still ongoing while they're working out getting him a new.
Okay, but that then gets to my same point. That if those matters are pending and he's on tether for that, these offenses then alleged to have occurred. My other question, what was he in prison for?
Only to that.
Receiving concealed motor vehicle.
Okay, so he's in prison for the receipt and concealment of a motor vehicle. He's on tether for something else.
That's a new case, right?
Well, the new case, but he's on a tether out of Macomb for something else.
He had been on tether out of Macomb, right?
The case for which he was incarcerated for was in Washtenaw County.
Was in Washington. And then, I have it run here. It was for receipt and concealment and concealing of a motor vehicle, unlawful driving away from an automobile. What is it?
Macomb.
Oh, I now have Macomb. Thank you. Yeah, okay. So his Macomb case is a weapon. So, well, that's why everybody's confused. Because his Macomb cases are a weapons, firearm receipt and concealment of a motor vehicle, firearms possession by a felon. Well, and those, yeah. So the Macomb County thing all occurred in from what I have here of an offense date of January 13th of 2023. Those charges are receipt and concealment of firearms or weapons, receipt and concealment of other motor vehicle, a stolen vehicle, weapons possession by a felon, felony firearm, and 2 counts of felony firearm. And that's what he's on the tether for.
That is my understanding of what he was on the tether for. Yes.
Right. So it's not just, well, then he misled the magistrate, quite frankly, because he told the magistrate, and my memory is still pretty good, I think, this time of day, but he told the magistrate that he was on the tether for receipt and concealment of a motor vehicle. Just kind of left the felony firearm and the firearms charge is kind of out of the mix.
Mr. Moore is indicating that he believes that she knew because the prosecutor had already told her.
Oh,
Prosecutor had already stated all the charges that I had.
I can understand. Hang on a second. The problem with that is she asked you specifically about the tether, as I'm recalling from the video. But the other part of it is that the very fact that we just had to go through all of this, it is very difficult to keep track of what you have because the charges are very similar from Macomb to here and then what you went to prison for. I mean, everything seems to revolve around some motor vehicle weapons. The only thing that's different here is now we have a CSC, but then we have another weapons charge. So that's hard to keep track of. Here's the other thing, and I am aware when warrants are signed. And so I bring this all into the mix only to say, and I'm not, the warrant itself wasn't sealed, so I'm just going to say it. There's at least some indication, because this involves a 14-year-old, this case here. There are some indications on the defendant's electronic devices, there are other young girls on there and indications of contact with other young girls. And so I say that to you because along with everything else, the defendant having been in prison on something, he get a 5-year term, whether he got out or not, whether he's on parole, that happens in November of 2022. By January of 2023, he is committing in Macomb County numerous other felonies. He is then at least alleged to then commit more felonies by, there was a July something. I don't know that it really matters, but he's then has, that's this one. Make sure I have my dates right. No, this one goes to
Sorry, Your Honor. He was also arrested in September 2023 and charged with home invasion, second, and larceny from a motor vehicle. Those cases
out of where?
here, those cases were ultimately dismissed in November.
Got it.
That's correct.
But I'm just saying, he's got these pending charges in Macomb. He has, then as he travels along, there are the other charges to come up. Granted, they're ultimately dismissed, but then you have these CSC charges coming up. There are then additional weapons charges that come up that he's just being arraigned on here. And given at least, and I don't know what's going to come out of it, but given at least what I've seen from the warrant, there may be additional CSC charges on minors coming up at some point. And he's hanging around a school. The latter half of all of that, from January at least, or from whenever he may have been arraigned in Macomb, all of that stuff is happening while he's on bond on the Macomb County thing. That in and of itself, quite frankly, it would be enough for me to deny bond, quite frankly, to him, given the nature of the charge. But if I just take the standard analysis of it, while none of this shows a propensity for flight, or that he would be a flight risk because he seems to stay in the same areas, Washington and Macomb County, committing offenses, so kind of know where he is, to under just looking at that, to say he's not a danger to the community, especially with the other information that I shared with counsel, there is no way I can't come to that conclusion that he's not a danger, not only to this particular victim, with the addition of sending pictures of weapons afterward. But after these charges are done, or filed, sending those pictures, he's got all of these weapons. He is clearly a danger to the community and to that victim, as well as these other potential victims. I don't believe for 1 minute that his promise that he's going to stay away from that school and these young girls, that will never happen. I can't believe that from him. So before I rule, is there anything else?
Your Honor,
Yes.
every time he was at Wave, he was invited. As I said, he was a student there previously, and his mother works there, and they have a food pantry and clothing, and he would go, and they would invite him there so that he could get things for his daughter.
Let's see fruitcakes.
Okay, all of that may be true.
That's all. I got that.
That
That's
they
all.
may have
Mr.
invited him there for the good purpose.
Mr. Moore.
However, I don't think he was invited there to prey on young girls. There are too many, well, I won't say there are too many, but the number of weapons charges are just, it's incredible to me. Further, when the people filled out their bond form, there were things that even the people weren't aware of that have come up since the time of that bond form that have become much clearer to this court. I frankly don't believe that the $100,000 bond request by the people is a high enough bond. I don't think that this defendant should be getting out pending adjudication of these cases. So I will grant the motion for the people. I am not, because I don't have to. I think that the magistrate was misled not only by the defendant, but it also wasn't clear. There are facts that the magistrate could not have possibly taken into account at that time. So not on an abuse of discretion standard, but because of other information that has now become available to the court in setting bond. The defendant's bond in that case is going to be set at $250,000 cash as surety. That will include all of the conditions that the magistrate initially put on his case regarding a GPS tether and other things should he post. On the new case that I'm arraigning him on today, I would indicate that I will order standard conditions, including no assaultive behavior or possession of any weapons. There is to be no possession of any alcohol, recreational marijuana, or any illegal drug. I'm going to add to that case, while it doesn't particularly involve that, there is to be no contact with any persons under the age of 18 on that
Would
case.
that exclude his daughter? What's your daughter's?
At this moment, yes. Ms. Gaines, and I don't like doing that, and I'm not doing it lightly. But when I have an individual that is alleged has 2 CSC offenses against a 14-year-old girl, I've got other indications that other young girls are being contacted by this defendant, that he's around a school. Frankly, I can't say that any young girl is safe around him. And so I'm not going to condone any type of contact, certainly not on what I know now.
Okay, all right.
And so it's no contact with any persons under the age of 18. With regard to his bond in that case, again, I think now that we've sorted out these numerous weapons charges, and I understand that it was a good faith request on behalf of the people, but I don't believe that his bond, the request by the people, is high enough with regard to all of these weapons charges. So his bond on that case will be set in the amount of $150,000 cash surety. Thank you.
Thank you all for staying to the end. I do hope you liked.
Bond? James Bond?
If so, please subscribe, and Bond and I shall see you next time. If you'd like to see a really cool judge take apart a criminal, please click on the episode on screen now.